What is the years of?
Pardon to mention, my lord, the appellant is questioned near about 10 years, my lord. In the meantime, co-accused person released. I have for bail.
Yes. ପାସବୁକ୍ ଅଛି କେତେଟା ଡାକିଦେ କେହି ନଥିବ ଡାକିଦଉନା ଅଛନ୍ତି କିଏ ହଁ କେହି ନାହାନ୍ତି ତ ହଁ ସେମାନେ ଜଏନ୍ କଲେଣି ସେ ସମ୍ବଲପୁର ଇଏ ଟିକେ ଖାଲି ଦେଖେଇ ଦିଅ
ଆଜ୍ଞା ଦେଖନ୍ତୁ ସେଠି
ଆମର ଆଇଟମ 3 ଏଇ ଯୋଉ ଆଜି ସପ୍ଲିମେଣ୍ଟାରୀ ଅଛି ସପ୍ଲିମେଣ୍ଟାରୀଟା ବାହାର କରେ
एडवोकेट राहुल ଆସିନାହାନ୍ତି
ନାଇଁ ସାର୍ ପହଞ୍ଚି ନାହାନ୍ତି ଫୋନ କରିଥିଲୁ ଆସିବେ
ହଉ ଠିକ ଅଛି ଆମର ହେମାନନ୍ଦ ପାଇଁ ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ଆଜି ଆରମ୍ଭ ହବାର ଥିଲା ସେଟା ଆରମ୍ଭ ହବ
I may require to address on the question of sentence because the other day I was held up there in a parted matter. Am I required to address anything? I don't. No, it is up to you, Mr. Sanangi, because he has given scanned everything. No, he has given a written note of argument. On that, if you want to say something, you can say. Otherwise, we will hardly say.
sentencing part that your lordship has seen
the both the sides. So, no. If you are free, you can sit. There is no problem. If you have some other work, you can. Right now. Okay.
Supplementary list item number 1.
Camera top.
My pleasure, Lordship. The death reference as well as the appeal lodge in jail criminal appeal 118 of 2023. The Lordship had
My reference is there. I'm just logging in your green room.
Yes.
your Lordship had the matter extensively.
On
ଅନେଇଛି କି ମାଇକ୍ ଟା
Your
please.
My Lord, that in the previous last several occasions, your Lordship had the matter in both the death reference and in jail criminal appeal 118 of 2023, advanced argued by my Lord Senior Milord, and supported the argument on that light. I am only submission before your Lordships. 2-3 points. The appellant convicted under section 302 and 34 of Indian Penal Code and the period of life imprisonment, my lord. And the appellant involved in the second incident where inside the village, my lord. There are 3 eyewitnesses in this case, my lord. In my case, my lord, that the PW1 was the daughter of the deceased Virabharti, who is the sister of the Savitri and the informant in this case, my lord. And PW3, one the minor son of Giridhari, and PW4 with the daughter of the Savitri, and 3 eyewitnesses there, my lord. The allegation against me, my lord, only restrain one deceased person, like namely Savitri, by holding her hair.
That was not the initial allegation. Initial allegation as per the FIR was totally different.
Yes, please.
That you participated in the assault
Yes, please.
of both the deceased,
Both the decision.
and you also dealt Tangia blow.
Yes.
That was the FIR story.
Yes, please. Deep look.
Right.
Yes, please.
So in trial, when these three witnesses examined, questions have been put and they have stated, no, this man was not holding any weapon.
Yes, please.
That is the,
That is the,
and only everybody has stated that assault was made by the other accused,
yes, please.
the father of this Hemananda,
Yes, please.
Nabin Devri.
Yes, Navin.
And the role, you are right, the role during trial that has been attributed against you is that when the mother was assaulted, the Savitri, that means the daughter, she was going to rescue
Yes,
her
please.
mother. At that point of time, you restrained her by holding the tuft of the hair. चुट्टी की धरिकिनी अटकेले
yes, yes,
बा तांको लोकल लैंग्वेज यूज करछन्ती 161 हम देखथुल छेकी देले भाई
छेकी देले आज्ञा.
That also means restraint. So that is one part. And another thing is that so far as the second incident is concerned,
yes,
which took place in that near the tube well, both of you, the father and son, they came together. You are present throughout, and your overtact is this. Then you left the spot together.
Yes.
And while decamping, it was told that we have already finished the Giridhari. So, Mr. Katkia's argument in the other day that even if Hemananda had not actually inflicted any blows, but his presence at the spot gave some kind of strength to the father who has already committed a murder. And when intention is a factor, according to Mr. Katkia, it can be ascertained through the conduct prior to the occurrence, at the time of occurrence, and after the occurrence. So even if there is no evidence of preconcept of mind like that, but at the spot it can also be from your overtact, looking at your overtact, it can be judged. So how do you meet?
But that the legal proposition is twofold, Lord. That the one, this related witnesses, your lordship's related witnesses,
no, you will
1, 2, 3 are the related.
We just will go to the decisions.
Yes,
don't burden us with decisions which are general in nature. If you say related witnesses are not truthful, then who will be truthful? Who else will come and depose? Their houses are nearby. They are seeing the occurrence, and so they are likely to. An independent witness may not be interested. So that is not a ground to discard the version of this. So please answer. Suppose the evidence of these three witnesses, as that has been stated by them, on this point, as far as it is possible, Mr. Sarangi also pointed out, so far as this part is concerned, they have very categorically stated that you are not armed with weapon. Your role has been limited role, but he is trying to bring it out that your presence, whatever overtact you have committed, that also is a factor for attracting the ingredients with the aid of the offense with aid of section 34.
Yes, ma'am.
So please reply to that. Don't go to the decision first.
No,
if you
34, 34 section 34, in this, our High Court also today 34 presumption that
read.
And we are of the view that it is not the case of the prosecution that when the occurrence stated that trespassing the house of the deceased and forcibly dragging him out of his house, the late accused Munu Maji and the present appellant had the common intention of committing murder, or that Munu Maji was armed with budia. Budia means that the axe. It borne out from the record that there was some dispute between the late accused Munu Maji and the deceased. Because of a dispute between the late Munu Maji and the deceased, an allegation that the deceased had kidnapped the daughter of the late accused Munu Maji. To settle the dispute, they had brought out the deceased from his house. There is no material on record to show that the accused person had common intention of committing murder of the deceased.
So here the fact is different.
Yes, ma'am.
Here
That
they
the
have
land,
common interest.
no, ma'am. That the case is the civil land dispute are there.
Here the common interest is both father and son have a common interest because the land of the family
Yes, ma'am.
was taken away according to them.
And the common intent is subsequent paragraph, my Lord Justice S.K.
And besides that also, there is an active as well as passive
passive.
overtake.
Yes, ma'am.
What is the passive one? He could have saved, deterred his father, refrained his father
Yes, ma'am.
from giving blows to the daughter
Yes.
after the hacking of the mother. That did not happen. Thereby, he facilitated the father by restraining the daughter to give blows. So active and passive both are there. He could have restrained his father.
Yes, ma'am.
Instead, he restrained the daughter. So the fact is different here.
Yes, ma'am. My Lord, your lordships can be turned to the PW1 statement.
ସେଇ ଯୋଉ କେସଟା ଆପଣ ସାଇଟ୍ କଲେ
Again.
ସେଇଟାରେ ଯାହା ଜଣା ପଡୁଛି ଜଣେ କେହି ବୋଧେ ୱେପନ ଧରିକିନା ଆସିନଥିଲେ ଘରେ ପଶିଲେ
Yes, ma'am.
ତାକୁ ଆଣିଲେ
Yes, ma'am.
ତାପରେ assault କଲେ ମେ ବି ୱେପନ ୱାଜ ଲାଇଂ
Weapon is like, yes, ma'am.
ଏଠି ବାପା ମର୍ଡର କରିକିନି ଟାଙ୍ଗିଆ ଧରିକିନି ରକ୍ତ ଲଗା ଟାଙ୍ଗିଆ ଧରିକିନି ଆସୁଛି ପୁଅ ତାକୁ ଜଏନ କରୁଛି ତାପରେ
Join me, Lord, that not the join.
no, they came together means
With
they
one-
came to the spot when the son is seeing that the father is having a tangia which is bloodstained. Son is joining the father because the son was not there at the initial stage. So son must have joined somewhere in between, na? Say your distance ta hochi 700 meters or something like that.
So they say 20 meters.
ଯାହା ବି ହଉ so ତାରି ଭିତରେ ପୁଅ ସେଠି ଥିଲା ବୋଲି କେହି କହୁନାହାନ୍ତି
Again.
ତ ତା ମାନେ ବାପା ଯେତେବେଳେ ସେଠି ମର୍ଡର କରିକିନି ସେକେଣ୍ଡ ସ୍ପଟ କୁ ଆସିଛି
Yes.
ତାରି ଭିତରେ ପୁଅ ତ ଜଏନ କରିଛି ଆଉ ଏଇଆ ହିଁ ଆମେ କହୁଛୁ ଜଏନ କରିବା ଆଉ ମାନେ କଣ
Again.
ଜଏନ କରିକିନି ବାପା ସାଙ୍ଗରେ ଆସିଛି ବାପା ଧରିଛି ଟାଙ୍ଗିଆ
Again.
ରକ୍ତ ଲଗା ଟାଙ୍ଗିଆ ଏବଂ ପୁଅ ଆସିକିନି ତାପରେ ବାପାର ଓଭରଟାକ୍ଟ ଏଇଆ ହଉଛି
Again.
ଏବଂ ପୁଅର ଓଭରଟାକ୍ଟ ହଉଛି ଏତିକି ହେଲା ତେଣୁ ସେଠି କ୍ୱେଶ୍ଚିନ୍ ହଉଛି what my esteemed brother is pointing out that a little change in the factual aspect also may change the ratio.
Yes.
So pura ha same identical
Yes.
thibo it is all right but ଟିକେ difference ଆସିଗଲେ ମଧ୍ୟ we may say that that ratio is not applicable because the factual scenario was different. We can, as my esteemed brother pointed out, so ସେଠି କୌଣସି accused weapon ଧରିକି ଆସିନଥିଲେ
Again.
ସେମାନେ ଘରକୁ ପଶି deceased କୁ drag କରିକି ଆଣିଛନ୍ତି ତାପରେ ଘଟଣାଟା ହେଇଛି whereas ଏ ଘଟଣାରେ already ଗୋଟେ murder କରିକିନି ଗୋଟେ accused ଟାଙ୍ଗିଆ ଧରି ଆସୁଛି ଆଉ ଗୋଟେ accused ତାକୁ join କରୁଛି so is there not any difference between the factual scenario of the two cases?
Yes, my Lord. That the form of recording the examination of accused, my Lord. Examination of accused. That accused statement, my Lord. That your lordships can turn to page 23, my Lord. The point is that the accused,
Just you please again we say that you come to the that very portion
my Lord,
in the FIR and that very
the
portion in the three
three
statements,
witnesses.
right?
Yes, ma'am.
So please come to the FIR.
Yes, ma'am.
କେବଳ ଆପଣଙ୍କ accused କୁ confine କରନ୍ତୁ
Yes, ma'am. Your
ତାନାରେ
lordships.
କଣ overtact ଦିଆହେଇଛି FIR ରେ
Yes, ma'am.
and how it is changing and if whether there would be any effect of it by changing the scenario.
Yes, ma'am.
So let us come to that.
The page 18, my Lord. The allegation.
Because this FIR has been lodged by one eyewitness to the
Eyewitness
offense,
of
right?
at the daughter of
आसंतु से पेज को पढ़े
page 18, page 18 my lord.
18 को आसंतु yes
till after 6th line my lord, after 6th line କିଛି ସମୟ ପରେ ମୁଁ ଘରୁ ବାହାରି ଆସିଲି, ଦେଖିଲି ନଳକୂପରେ ମୋର ମା ପାଣି ମାରୁଥିଲେ ଓ ମୋ ନାନୀ ବୋତଲରେ ପାଣି ଭର୍ତ୍ତି କରୁଥିଲେ। ହଠାତ୍ ଏହି ସମୟରେ ମୋର ମାକୁ ପୀରବତୀ ବେହେରାଙ୍କୁ ଆମ ଲପଡ଼ା ଗ୍ରାମର ନବୀନ ଦେହୁରୀ ପିତା ତ୍ରିଲୋଚନ ଦେହୁରୀ ଓ ନବୀନ ଦେହୁରୀଙ୍କର ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଟାଙ୍ଗିଆରେ ହାଣିଦେଲେ।
এই জিনিসটা এই যে সেকেন্ড পার্টটা ସିଏ ଟ୍ରାଏଲ ଷ୍ଟେଜ ରେ ଅଲଗା ଷ୍ଟୋରି
ଇଏ ଡିପ୍ଲୋମାଇଜ
yes that is one then
and ତାଙ୍କର ଚିତ୍କାର ଶୁଣି ଆମ୍ବ ଦାଣ୍ଡ ବାଟରୁ ଚିତ୍କାର ଆସୁଥିବା ପଟକୁ ଅନାଇଲୁ, ଦେଖିଲି ଉଭୟ ନବୀନ ଦେହୁରୀ ଆଉ ତାଙ୍କ ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ମୋ ବଡ ଭଉଣୀଙ୍କୁ ଧାରୁଆ ଟାଙ୍ଗିଆରେ ଗୋଡାଇ ଗୋଡାଇ ହାଣିଦେଲେ।
again this is not there in the during the trial
yes lord
okay
ଓ କହିଲେ କିରିମିରିଆକୁ ମଧ୍ୟ ବାଟରେ ହାଣି ଦେଇଛୁ କହି ରାଗରେ ଦୌଡ଼ା ଧୌଡ଼ି ହେଇ ଆସିଲେ। That's also the contradiction.
so what do you find from here? What is your submission?
My submission
how the prosecution case during trial is different from the story which is narrated by an eyewitness in the first information report. How it is different?
Milord, your lordships can turn to
no you say ଆପଣ ପଢିଲେ ନା
difference between
different କଣ ଆପଣଙ୍କର
that's ଏ କହୁଛନ୍ତି ଦି ଜଣଙ୍କ ହାଣିଲେ
so ଏକ ନମ୍ବର ହଉଛି ଦୁଇ ଜଣ ଯାକ assault କଲେ ସେ ଯୋଉ ପୀରବତୀକୁ
ଆଜ୍ଞା
ସେଇଟା ଟ୍ରାଏଲ ରେ ଷ୍ଟୋରି ନୁହେଁ prosecution case ନୁହେଁ
ଆଜ୍ଞା
ଦୁଇ ଜଣ ଯାକ ସାବିତ୍ରୀକୁ ମାରିଲେ
ଆଜ୍ଞା
ଏକଥା ମଧ୍ୟ ଟ୍ରାଏଲ ର ଷ୍ଟୋରି ନୁହେଁ
ଆଜ୍ଞା
ରାଇଟ୍
ଆଜ୍ଞା
ଆଚ୍ଛା ମାର assault ବେଳେ ଝିଅ ଯାଉଥିଲା ଅଟକେଇବାକୁ ଆଉ ଇଏ ତାକୁ ରିଷ୍ଟ୍ରେନ୍ କଲା ଏ କଥା ଏଫଆଇଆର ରେ ନାହିଁ ରାଇଟ୍ ଏଇଟା ସେମାନେ ଆଣିଲେ ଫାର୍ଷ୍ଟ ଟାଇମ ଡ୍ୟୁରିଂ the trial of story 161 ne pureki tapre anchali hala so these are the basic difference between the two cases so that is exactly Mr. Sarangi was pointing out that semane jo case ta ko initially present koruthile for some reason or other they changed it and give a different version maybe during 161 as well as in the trial stage
yes
right so this is the story right
yes,
now you will go to the
eyewitness yes,
eyewitness mane
you mean
PW1
PW1 yes
okay.
The PW1 page 66 now
you come to the last three lines
yes,
of that page
yes,
66
at that time my lord the last two lines my lord the chief my lord the page 66 last two lines
nahi out gote line purvuru padantu I found
my mother was pumping the tubewell and my sister was pouring water in a bottle at that time both the accused persons came and accused Nabin suddenly dealt a blow by means of an axe on the neck of my mother. Then seeing this, my sister threw the bottle and went to rescue my mother, but accused Hemananda restrained my sister by dragging her hair. Accused Nabin gave conjunctly 3 to 4 blows on neck of my mother, and she died on the spot.
then thereafter
both the accused persons restraining my sister went on giving blows by means of tangia on different parts of her body, and she also died at the spot.
So this particular line,
yes,
of course, he has stated in the chief examination, but something else has been stated in the cross. So far as the Sabitri is concerned,
Yes, ma'am.
According to PW1, the assault was also given by Hemanand,
Hemanand.
right?
Yes, my lord.
So thereafter, both the accused
Both the
persons
accused person. Yes,
restraining my mother went on giving blows by means of a tangia on different parts of the body.
yes, ma'am.
And then next line.
The accused persons were telling loudly
Hmm.
that they have killed my brother-in-law Giridhari.
Hmm.
The accused persons were telling
Hmm.
loudly that they have killed my brother-in-law Giridhari.
Okay.
Out of fear, I along with
But
my niece.
Mr. Das,
Yes, ma'am.
you can't expect the witness to be so precision in the statement while giving an evidence if it has come broadly in the FIR.
No,
First of all,
yes.
whether there is an introduction of a story altogether, or it is an improvement, it is an exaggeration.
No, but that the
What is that?
affair.
So, if you go so minutely with a stray sentence or a sporadic word putting in a evidence, then there is no evidence. You
No.
mean that either FIR should be reproduced or 161 is to be reproduced. It can't happen. A natural witness has to differ, and differ not on material aspect. In the material aspect, FIR has given the details about the presence of both. So, by saying that both had, both stated, that doesn't mean that the witness has the interest of introducing a thing. While giving an evidence, as such, you know that they are villagers. Even a literate person, while giving an evidence, it cannot be expected that he will be so precision in his statement that he would replicate what he has stated either in the FIR or in the 161. It cannot be expected. So it is a natural way that a witness, unless that introduction, that exaggeration, wholly or substantially changing the story of the case. Here, there is no change in the story. There is an elaboration.
My lord,
Both.
your lordship,
That is an elaboration. Both.
your lordship, right, not. But in the subsequent, the cross-examination, he denied all these things, not.
All right.
We'll see that.
We'll see that.
Yes,
That is appreciation.
That is pointed out. That is pointed out that
Mr. Sarangi has pointed out.
suppose whatever you have elicited by way of contradiction, referring to the previous statement, either made in the FIR or in the 161 statements, it is contradictory to that extent that both cannot stand together.
The
Right?
extent of top hair
ତେଣୁ
is not there.
ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଆପଣ ଆଣିଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ୟୁ ସି ୟୁ ହାଭ୍ ପୁଟ୍ ଦି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ଆପଣଙ୍କର ଯୋଉ ପାରାଗ୍ରାଫ 3 ରେ ପ୍ରିଭିୟସ୍ ଷ୍ଟେଟମେଣ୍ଟ ଆଉ FIR ଉପରେ ଆପଣ କ୍ୱେଶ୍ଚିନ୍ କରିଛନ୍ତି ହେଲା now you come to the IO କାରଣ ସେଦିନ
No, that the cross-examination one paragraph. Your lordship can turn to page 69, para
Yes.
8, para 8.
Hmm.
Para 8, that after 10 line 1. After 10 line, I cannot say. After 10 line. I cannot say if any other person had witnessed this incident. Next line is very important, Lord. That while Nobin was assaulting and the accused Hemanand was holding my sister.
No, that is, you see, the other witnesses have made a very categorical statement.
Yes.
That this man was not at all holding any weapon. We'll come to that. 3 and 4, they are very clear. In the hand of this Hemananda,
yes,
there was no weapon.
Yes,
very clear. Only Nabin was holding the weapon. We will come to that. So, the role which PW1 is attributing that both of them assaulted in view of PW3 and 4,
yes.
That may not be, as you say, it may not be accepted that he was having any weapon to that effect. But you see, what we are pointing out to you, that was this contradiction part in paragraph number 3,
Yes, ma'am.
which has been put and that has been proved through the IO PW20, page number 134 and paragraph is 27. So you come to that.
Yes, Miller. Yes. Yes, Miller. Paragraph 27. That the cross section next fact is 135.
No, you please place that paragraph. Paragraph 27.
Yes, Miller. It is not a fact that witness, namely Manika.
Just mark it. It is not a fact he is telling.
Yes, Miller. It is not a fact that witness, namely Manika Puste, PW1, has not stated before me in her statement that she being called by her brother-in-law one day prior to the incident had been to village Lapada, and that about 2:30 p.m. his elder brother-in-law went to the paddy field, and after 15 to 20 minutes, her mother and elder sister left house to the paddy field.
Towards the paddy field.
No, what does it mean? It is not a fact. तामाने आपण सेटा पचारी कि नहीं
ଆଜ୍ଞା
जो प्रमाण करिया को चाहिले इन्वेस्टिगेटिंग ऑफिसर पाकू
ଆଜ୍ଞା
आपण ताकू कहिसेंती देखो ए विटनेस एया सब आपण पाखरे कहिनी सी कहूची कहूची नाही हां कहिची बेली it is not a fact that maybe that whether this not has been added or not, then we have to verify. In fact, for the interest of justice, we can see the 161 that you dekhele. Sakhiro, please bring out. Maybe that not has been added like that, or whatever the IO is telling that is correct. Apan pakhre 161 statement achi ta? Ha. Se manikyor bhar konon. PW1 no. Ha, no, see. Thank you. Mr. Kotki, I think you have got that one. Yes.
Yes, Miller.
Please place that.
But the relevant portion that 161.
No, आपण पढू नांती से तो आपण जहा पचाल से कहला नाही मो पार सब कहिछि ना आपण पचार ना पढू नांती कोन स्टेटमेंट पढंतु
मु श्रीमती माणिक पुरते
से स्वान सो छाड़ दियंतु हां
आज 21/1/2020 तारीख दिन आपनकु देबा मोर बयान कहि जे मोर बापा मृत
यस
आपण पळे आसंत आउटे तळकु सीधा
आउटे पळे आसंत
मु गतकाली दशहरा निमंते आम घरे बुली आनंद आम घर बुली हां मोर स्वामी मते काली गां रे छाडी दे
हां से छाड तापरे पळे
सकाळ 10टा रे एमा सकाळ मोर मां बड़ भौणी सावित्री ओ भिणई
धान काटी
होगा धान काटिबा को गले फेरी आसिले मु रंधा बढा କରିଥିଲି ସବୁ ଖାଇଲୁ ଓ टीवी देखिलु पुणी 2:30
एइटु एक्चुअली आरंभ एइट पढ
पुणी 2:30 हेबो सेमाने धान काटी जमी को बाहरिले मोर भिणी आमे गले आगे
से गिरधारी जी
आगे गले परे
अधघंटा असुविधा होची आपण पढिया पई
नै एटा लेजिबल
अच्छा मिस्टर कटकिया ये प्लेस कले आपण लेजिबल कॉपी जी
नै एटा देखाउनी आपण एटे मोर अछि लेजिबल
मोर भिणे आगे गले परे अध घंटा हेबो आमे भौणी ओ मा सह दुख सुख हेई ओ मोर भौणी सावित्री ओ मा पीरवती धान काटी गले से माने कबाट लास्ट लाइन टा
से कबाट
से माने कबाट आउजेई देई गले हेले मु अल्प समय परे कबाट देवी कही बाहर बखरा को आसिले हां मोर पछे पछे
मोर झियारी स्वप्ना और पुतुरा
से जो PW3 एंड 4 हां
मध्य आसिले सेतरे मोर मा पीरवती ग्राम पंचायत नळकूप जहा कि आम जमी को जीवा रास्ता रे अनुप चौधरी को घर शेष अच्छी सेठी पानी मारुथिले ओ भौणी बोतल रे पानी भरुथिला एही समय आम पड़ोसी नवीन देहुरी पिता त्रिलोचन देहुरी ମୋର ମାକୁ ଟାଙ୍ଗିଆରେ ହାଣିଦେଲା। କଣ ଏପରି ହେପାରି ମୋର ମା ଏମିତି ଚିତ୍କାର କଲା କହି ମୁଁ କାଟିକେ ବାହାରକୁ ବାହାରିଲି। କବାଟ ପାଖେ ଦେଖିଲି ନବୀନ ଦେହୁରୀ ମୋର ବଡ ଭଉଣୀ ପଛେ ପଛେ ଗୋଡାଉଥିଲା ଓ ଗାଁ ଦାଣ୍ଡର ତାକୁ ମଧ୍ୟ ଟାଙ୍ଗିଆରେ ଚୋଟ ମାରି ଚାଲିଥିଲା। ଏହି ସମୟରେ ନବୀନ ଦେହୁରୀର ପୁଅ ହେମାନନ୍ଦ ଦେହୁରୀ ଆଲିଆସ ମଣ୍ଟୁ ମୋର ମାକୁ ମାରିବା ସମୟରେ ସେଠି ଜଗି ରହିଥିଲା ଓ ଭଉଣୀ ଦୌଡ଼ିବା ସମୟରେ ଛେକି ରହିଲା। ଫଳରେ ସେମାନେ ସେଇ ସ୍ଥାନରୁ ଖସି ଯାଇ ପାରିଲେ ନାହିଁ। ଏହା ଦେଖି ଆମକୁ ଟିକେ ମାରିଦେବ କହି ଆମେ ତିନିଏ ଘର ଭିତରୁ ଦୌଡ଼ି ପଶିଲୁ।
So that is the story. ଏଠି ସେଇ ଷ୍ଟୋରି ହଉଛି ସେଇ ଯେ ନବୀନ ଦେଉରୀ ହିଁ ଆକ୍ଚୁଆଲି ମାନେ ତାଙ୍କର ମାନେ ସେ କହୁଛି ନବୀନ ଦେଉରୀ ହିଁ ଟାଙ୍ଗିଆରେ ଆସଲ୍ଟ କରୁଛି। ଆର ରୋଲ ଟା ହଉଛି ଅଲଗା, ଯୋଉଟା କି ଯଦିଓ ଏଠି ଚିଫ ରେ ଗୋଟେ କଥା କହିଛି ଯେ ଇଏ ମଧ୍ୟ ପାର୍ଟିସିପେଟ କଲା ବୋଲି, ଯୋଉଟା କି ଅନ୍ୟ ଆଇ ୱିଟନେସ୍ ମାନେ କହିନାହାନ୍ତି, କିନ୍ତୁ ଏଇ ଇଏଟା ଆସିଛି। That is why we asked also on the other day to Mr. Katkia. Katkia said, no, the evidence on record is very clear that Nabin Dehuri is the only person who was holding the Tangia, and with that Tangia, he assaulted all the three deceased. Question is, even if he has assaulted, whatever you have done at the second spot, whether it attracts section 34 of the IPC or not, that is to be considered. Whatever you have done, that is as per the evidence.
And he could have said that they have exaggerated or improvement had they not been naturally stated that that Hemananda was armed with weapon. Had they said, they have clearly said Hemananda had not inflicted blow. Hemananda was not armed with weapon. It's very clear. So the sentence, if at all has come, both will not be taken that way, that they have tried to introduce off, except 30.
Yes, ma'am.
So anything else from the तो এই जो आपण पचारिले, that is what we are pointing out. जदि एगुड़ाक सब 161 रे अच्छी ताले आपण से सरकारी वकील सेठी करूथिले कोन, ये जेतले कन्फ्रंट कले एवं ट्रायल कोर्ट केमती अलाउ कले एगुड़ाक एई टाइप रो रेकॉर्डिंग करिवा पई। से कहउचंती दैट प्राय almost everything is there जोटा की चीफ रे कहउचंती, except that both the disease जो कहउचंती टांगिया रे सेही पार्ट टा को छाड़ी देले, बाकी सब जिंस आपण पढिले ना से लोकल लैंग्वेज रे चेकी देले माने होची अटकेइले। एठी भी कहउचंती अटकेइले, को वे रे अवश्य अटकेइबाटा से कहनी, एठी जोटा कहउची जे छुट्टी धरि किनी अटकेइले हला। So this is one evidence. So what you want to further say on this PW1? What is your further comments on PW1?
No, ma'am, that the affair.
Why we disbelieve the role that has been attributed against you by PW1?
No, ma'am, that the PW1 is like the related witnesses.
Yes.
The related witnesses.
So your first point is that PW1 being a related witness,
Yes, ma'am.
his evidence should not be accepted.
Yes,
that is your
yes,
submission.
Yes, ma'am.
Okay. Any citation to that?
Yes, ma'am.
effect?
That the citations, ma'am.
So that is principle.
You lost 2017.
2000?
2017. 13 SCC.
13 SCC.
Page 98. Ma'am.
Page 98.
Krishna Gowda and others.
Krishna Gowda.
Yes, ma'am.
Versus
State of Karnataka.
Yeah.
That the appeal against the acquittal in this case, ma'am.
No, it's all right. Principle, just
Principle decided, ma'am. That your lordship paragraph
kete
32 and 33, ma'am.
Padon.
It is to be noted that all the eyewitnesses were relatives and the prosecution failed to adduce reliable evidence of independent witnesses for the incident which took place on a public road in broad daylight. Although there is no absolute rule that the evidence of related witnesses has to be corroborated by the evidence of independent witnesses, it would be trite in law to have the independent witnesses when the evidence of related eyewitnesses is found to be incredible and not trustworthy. The minor variation and contradictions in the evidence,
Yes.
the minor variations and contradiction in the evidence of eyewitnesses will not be the benefit of doubt in favor of the accused, but when the contradiction in the evidence of a prosecution witnesses proves to be fatal to the prosecution case, then those contradictions go to the root of the matter, and in such cases the accused gets the benefit of doubt. And next paragraph 33, my lord. It is the duty of the court to consider the trustworthiness of evidence on record. As said by Bentham, witnesses are the eyes and ears of justice. In the facts on hand, we feel that the evidence of these witnesses is filled with the discrepancies, contradictions, and improbable version, which draws us to the irrespectable conclusion that the evidence of these witnesses cannot be a basis to the convict the accused.
So कौन देखिले ता देहरे कहिले जे से रिलेटिव विटनेस तांको सहित इंडिपेंडेंट विटनेसेस स्पॉट रे थिले.
Yes, sir.
प्रोसिक्यूशन कोनोसी इंडिपेंडेंट विटनेस को आनिला नाही. येला नंबर 1. नंबर 2, जो रिलेटिव विटनेस को प्रोसिक्यूशन आनिला ता देहरे कॉन्ट्राडिक्शंस बहुत थिला टू ए ग्रेट एक्सटेंट.
Yes,
नंबर 3, से रिलेटिव विटनेस माने जो वर्सन देले दैट इज एन इम्प्रोबेबल स्टोरी.
yes,
तो एई बेस को नेकिनी कोर्ट बिलो एक्यूटल करथिले, हाई कोर्ट एक्यूटल करथिले. तेणु एक्यूटल करिथिले, एक्यूटल रो रीजन टाकू सुप्रीम कोर्ट फाइंड करथिबे जे इट इज नॉट ए परवर्स. कारण एक्यूटल रो जेतेबेले एप्रिसिएशन हुए मियरली बिकॉज I can take another view, that is not a ground to interfere the order of acquittal. तो से assessment रखिकिनी सुप्रीम कोर्ट को जज करछनी. आपण जो प्रपोजिशन एडवांस करूछंती जे रिलेटिव विटनेस आपण डिस्कार्ड कर दियंतु. तेणु ताहाले प्रोसिक्यूशन ताले कोहा जीवो जे चार्जशीट रे जेतिक रिलेटिव विटनेस होउथिबा आ तांको देखैबनी चार्जशीट विटनेस हिसाब रे. तांको तो बिलीव होबनी आ तांको चार्जशीट विटनेस काहे देखैबो. टोटल एग्जामिन करबनी. घर भितर घटना होईची, पाखापाखी घटना होईची, खाली रिलेटिव माने होईचंती, प्रोसिक्यूशन तांको एग्जामिन करियो छाड़ियो नाही. बाबू तुम काहे काम करियो. हमें हाई कोर्ट लॉ कर देला रिलेटिव विटनेस को हमें विश्वास करबनी, हमें तुमको एग्जामिन करबनी, चार्जशीट भी दबनी, तुमको साइड करबनी. डू यू मीन टू से दैट?
No, sorry, that my submission before lordship law, the related witnesses corroborate to the independent witness also.
Are eti have you brought out any material on record that in that spot there are other witnesses present and they saw the occurrence? Number 1.
Yes.
Have you brought out anything?
No.
So how do you then say that say जो proposition आनुचंती independent witnesses थिले तांको prosecution deliberately withdraw कर देला, केवल जो माने interested witness, relative witness माने से मानो interested witness तेणु से मानो को देइछे. How can you advance such an argument?
The investigating officer also not examine the neighbors also. That is the case.
आपण को टाइम रे occurrence होची देखंतु. खराबेळ समय रे चाष करिया जाउछंती, हुए तो सेतबेले अन्य माने विश्राम नउथिबे. इट मे बी पॉसिबल. तेणु आपण जदि आनी थांते क्रॉस एग्जामिनेशन रे जे घटना बेले एई माने सब ठियाई किनी देखुतिले, रादर एविडेंस आसीची जे घटना परे लोक माने आसीचंती एवं से साक्षी मध्य आसीचंती, एविडेंस देइचंती. बट दी असॉल्ट समय रे कोनोसी इंडिपेंडेंट विटनेस प्रेजेंट थिले स्पॉट रे ये एविडेंस ही आपण आनना दी. तेणु से जो रेशियो आपण प्रपोजिशन एडवांस करूछंती ସେଇ କେସ୍ ର ଇଏ ତ ତାଳମେଳ ହଉନି, ସେଥିରେ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ ଥିଲେ ତାଙ୍କୁ ଦେଲେନି, ଖାଲି ରିଲେଟିଭ୍ସ କୁ ଦେଲେ, ରିଲେଟିଭ୍ସ ଙ୍କର କଣ୍ଟ୍ରାଡିକ୍ସନ ଆସିଲା, ମେଜର କଣ୍ଟ୍ରାଡିକ୍ସନ, ଏବଂ ସେମାନେ ଏମିତିଆ ଷ୍ଟୋରିଟା କଲେ ଯେ ସେଟା ପ୍ରୋବେବୁଲ ନୁହେଁ ଆକ୍ସେପ୍ଟ କରିବାକୁ। ସେଥିପାଇଁ ଗୋଟେ ଆକ୍ୟୁଟାଲ ଅର୍ଡର କୁ ଅନେବୁଲ ସୁପ୍ରିମ କୋର୍ଟ ଇଣ୍ଟରଫିୟର କରିବା ପାଇଁ ରାଜି ହେଲେ ନାହିଁ। ବଟ୍ ଦିସ୍ କେସ୍ ଇଜ ଟୋଟାଲି ଡିଫରେଣ୍ଟ। So any other submission on PW1?
But that's the
Then you go to the, if that is all, then go to the next witness, PW3. See what overtact he has attributed against you. PW3 Sachin Sahu.
Your Lordships can turn to page 74.
74. Yes, please come.
The alleged incident was happened on 21/10/2020 around 3 p.m. On that day, at morning, my father, my mother, and maternal grandmother had gone to our cultivable land around 12:30 a.m.
PM.
They returned from the field. After taking lunch, my father again left to go to our land at 2:30 p.m. After a while, my mother and grandmother left the house. Following them, myself, my sister, and Mausi, Monica Prusti, PW1, came outside. At a little distance from our maternal uncle's house, there is a 12. While my maternal grandmother was pumping the tubewell and my mother was collecting water in a bottle to take to the field, at that time, accused Nobin Dehuri and Hemananda Dehuri came to that place and Nobin was holding Tangia. He dealt blows to my maternal grandmother while my mother went to protest him. Accused Hemananda Dehuri restrained her by dragging her hair and accused Nobin also assaulted by mother by means of Tangia. The native village, my father is at village Kirimira. As my father was domesticated son-in-law, he was residing in my maternal uncle's house at village Lapada. The people of Lapada called my father as Kirimiria. Accused Nobin Dehuri was telling loudly that they have also killed Kirimiria. Out of my fear, my Mausi took me and my sister to the house and closed the door. We raised hula, hearing to which many villagers surrounded at the spot. We came outside and found both of my mother and maternal grandmother were lying dead. Thereafter, information was given to the police. It was seen to the father also the culpable land.
So you see, when the villagers arrived at the scene of occurrence,
Yes, ma'am.
they only arrived after everything was over.
Yes, ma'am.
Because if this witness said, we raised holla,
We raised a holla,
and then the villagers
yes,
came.
yes, surrendered.
Yes.
And the relating to our landed property, there was a long-standing dispute between my maternal uncle's family and family of the accused persons. Relating to this incident, I was examined by police.
Now, the role that is attributed in the chief examination
Yes, ma'am.
is very clear that when the Savitri went to protest,
Yes, ma'am.
you restrained her by dragging her hair.
Yes.
Eti hochi apanଙ୍କର role, right?
Yes, ma'am.
Now, you have in paragraph 4, you have put the 161 CRPC statement of this witness and you come to the third line of paragraph 4.
Yes, my lord. Hemananda dragged here.
No.
I do not recollect.
हाँ.
I do not recollect.
Hmm.
If I had not stated before the police that while my mother went to rescue my maternal grandmother, accused Hemananda dragged her hair and did not allow her to go.
ताले एई जिनसटा आपण तांको पचारले. Now you come to the IOS evidence. PW20 page is 136, paragraph is 30.
30 years, my lord. 30. It is a fact.
Wait. Page is 136. And paragraph is 30. Yes, now you read it out.
Fact that witness named C.Dash PW3 has not stated before me in his statement that while her mother went to rescue her maternal grandmother, the accused Hemananda dragged her hair and did not allow her to proceed, and that out of fear her aunt
तो ये जो बाळकु धरिबा कथा अटकेइबा कथा जोटा कि से चीफ रे कहिची सेटा इनफैक्ट 161 ने नाइ बेली आईओ कहिची.
yes,
नाउ यू कम टू दी 161 एपटी बाहर करले सचिन साहब स्टेटमेंट.
yes, madam.
सेई पार्ट टाकू देखंतु अच्छी आपण पाखरे सचिन
last part of
मिस्टर कटकिया यू आर हैविंग दैट कॉप स्टेटमेंट. हां
the operating part.
नहीं सेई पर्टिकुलर कॉन्ट्रैक्शन टा पढो.
yes. नवीन देहुरी मोर मां
को लाइन टा मोर भूमि स्वांतो
second page पे first page
सेकंड पेज रे. अच्छा
second page
पर
second page रे 1 3 4 5 6 7
हाँ मोर बापा बिलो को जीवा पई बाहरिले मुई भी आसिली सेटा पढुचन तो सेकंड पेज रे.
आज्ञा
हाँ फाइल हाँ
मोर बापा बिलो को जीवा पई बाहरिले
मुई भी
आसिली तार बापा आगे
अच्छा मोर बापा
हाँ मोर बापा आगे भाग देले मोर आई ओ माँ
हाँ टीवी देखी टिके कथा हेले
टीवी
ओ जमी को
कथा हेले नो को बाहरलु
तापर पण
तापर से
सेते बेले तीनिटा
होइथिला मोर आंटी कबाट
आंटी माने PW1
आसीबारु आंटी माने पिड़ा गया कबाट खोलिबा को आसीबारु आसीबा पछे पछे मु ओ मोर भौणी
सपना PW4
भी आसिलु. कबाट पाखे मोर आंटी अधा खोला करी रहिबारु से फांका आडू मोर माउसी पछरे रही मु ओ सपना देखिलु जे मोर मोर आई पीरवती बेहेरा यात्रा मंडप नलकूप पाखे पानी मारुथुबा जागारे थिला ओ आम ग्रामर नवीन देहुरी ताकू टांगिया रे हाणुथिला. सेठी मंटू देहुरी आपिलांड माने हेमानंद मंटू देहुरी पाखे ठिया होइथिला. परे मोर मा नलकूप पाखु दौड़ुथुला. नवीन देहुरी मोर मा पछे पछे गोड़ाई गाँ दंडरे ताकू टांगिया रे चोट मारिथिला. मोर मा निजे तळे
परे चोट माने चोट ऊपर चोट हां मारथिला
चोट परे चोट मोर मा तळे पड़ी चित्कार करूथुला. मोर दौड़ुथुबा बेले मोर मा दौड़ुथुबा बेले मंटू देहुरी रोल ऑफ द पिटिशनर असला पिलान मंटू देहुरी मोर मा के
छेकी देला माने होची अटकेई देला.
यस
यस सो हेले मोर हां
हेले मोर मा भाग पारला नहीं
भागी
पारला नहीं. ए सबु देखी मोर आंटी कबाट खोली देला नवीन देहुरी सेई टांगिया धरी रास्ता के किरिमेरा हाणी देइछि कहिला. आमे समस्ते घर भितरे रही चित्कार कलु.
So you see in the 161 the witness has used a local language.
Yes,
that cheki dela.
Yes,
Cheki dela ra mane hochi atkei dela. In the trial court, he has stated, say Otkela, but by this way he restrained. Manner of restraint.
has been stated.
Tenu, it is not that there was no statement
At
at
all.
all that you have restrained this lady, the
yes.
third disease, that means Savitri.
Yes,
So that is there, but the manner of restraint that is stated in the, so only that is the minor elaboration jaha point out କରୁଛନ୍ତି my esteemed brother, that elaborately se କହି ନଥିଲା ଯେ କୋଉ ପ୍ରକାର. So that may be a fault of the investigating officer.
yes, madam.
Investigating officer तो ସେତେ elaborately ସେ statement ଟା collect କରିନି ଯେ ଯୋଉ କହୁଛ ଛେକି ଦେଲା, କେମିତି ଛେକି ଦେଲା, ହାତରେ ଅଟକେଇ ଦେଲା ନା କେମିତି. So ସେଇ ୱିଟନେସ୍ ଆସିକିନି ଯେତେବେଳେ କୋର୍ଟରେ କହୁଛି ଯେ ଏଇଭଳି ଅବସ୍ଥାରେ ଛେକି ଦେଲା ମାନେ ଅଟକେଇ ଦେଲା ହେଲା, ତ ଯେତେବେଳେ କନଫ୍ରଣ୍ଟେସନ ହେଇଗଲା 161 ଟାକୁ ଆଇଓ ଦେଖିକିନି ପ୍ରମାଣ କରୁଛି, ସେତେବେଳେ ଏଇ ଜିନିଷଟା ଆଣିବାର ଥିଲା ଯେ ବଟ୍ ହି ହାଜ ଷ୍ଟେଟେଡ that he has restrained the movement of the, ସେ ଜିନିଷଟା ଆଣିବାର ଥିଲା, that was the duty of the public prosecutor to point it out. ବର୍ତ୍ତମାନ ଆଣିଲାଠୁ କଣ ହଉଛି ନା ଟୋଟାଲ ଯେମିତି ଆଜି କିଛି ଷ୍ଟେଟମେଣ୍ଟ ନାହିଁ, ସେଇଟା ଛେକି ଦେଲା, ଅଟକେଇ ଦେଲା କହିନି, ତେଣୁ ତାର କିଛି ରୋଲ ନାହିଁ. But in fact that is there in the 161 statement.
Yes,
so here we are discussing about this, that some way this public prosecutor who has conducted the is also negligent. He should have been very with almost promptitude, who should have attended what is the being confronted, whether it is totally there or not. ହେଲା ତାପରେ କାହିଁକି କୁହାଗଲା ଯେ ମାର୍କ କରିବାକୁ ସେ ପର୍ଟିକୁଲାର ପୋର୍ସନ ଯୋଉଟା କଣ୍ଟ୍ରାଡିକ୍ସନ କରୁଛି ଏମିତି ସେଟାକୁ ମାର୍କ କରିବ, ତାକୁ ଏକ୍ସ ମାର୍କ କରିବ, ଏବଂ ଯେତେବେଳେ ଆଇଓ ଆସିବ ସେଇ ମାର୍କ ପୋର୍ସନ ଟାକୁ ତାକୁ ଦେଖିବ ହେଲା. So why we are going to 161 then? Can we rely on 161 and decide a case? No. But in the interest of justice, to see that what is the actual statement
or the extent of omission.
So in that interest of justice, we are compelled to verify, because we are time on number, we are seeing that in this case, this is the conduct of the public prosecutor. जो जिनस अच्छी से पचारि चलची, तमे एमती कहिन, से किछि कोनी रेकॉर्ड ही चलची, आईओ भी ताकू प्रूव कर दी चलची, बट इन फैक्ट देखिला बळकु से जिनस अच्छी. So the London trial court, as it is stated in a number of decisions, is not a typing machine. So he should be very careful. With almost promptitude, he should control the proceeding. ତା ପାଖରେ ମଧ୍ୟ ଟ୍ରାଏଲ କୋର୍ଟଙ୍କ ପାଖରେ ମଧ୍ୟ ଯେତେବେଳେ କନଫ୍ରଣ୍ଟ ହଉଛି ପ୍ରିଭିୟସ୍ ଷ୍ଟେଟମେଣ୍ଟ, ଡିଫେନ୍ସ କାଉନସିଲ କନଫ୍ରଣ୍ଟ କରୁଛି, ସେତେବେଳେ ନଟ ଓନ୍ଲି ପବ୍ଲିକ ପ୍ରସିକ୍ୟୁଟର ବଟ୍ ଟ୍ରାଏଲ କୋର୍ଟ ମଧ୍ୟ ତାକୁ ଦେଖିବା କଥା ଯେ କଣ୍ଟ୍ରାଡିକ୍ସନ ଅଛି, ଯଦି ମାଇନର କଣ୍ଟ୍ରାଡିକ୍ସନ କି ମେଜର କଣ୍ଟ୍ରାଡିକ୍ସନ କୋଉ ଭାବରେ କଣ୍ଟ୍ରାଡିକ୍ସନ ହେଇଛି ଅଛି, ତାକୁ ନକରି ଯାହା ନାହିଁ ତାହା ରେକର୍ଡ କରିଦବ, ପୁଣି ଆଇଓ ଆସିଲା, ସେ ତାର ମେକାନିକାଲି ସେଗୁଡାକ ପ୍ରମାଣ ହେଇଗଲା. ତେଣୁ that is not the way in which a case is to be dealt with. Tenu, if we accept this statement, then the thing that is unfolded from the evidence of, or through the evidence of PW3, that when one of the deceased was assaulted and the other deceased was going to rescue her, right? At that point of time, you check the movement of the second deceased by holding the tuft of the hair. That is the role that has been attributed. Right? Okay. So now, if that is the role, and she has also very made very clear in paragraph 8, Mr. Sarangi also pointed out on that day. Come to paragraph 8 of PW3. Page 76.
No assault. Yes, ma'am. Page 76.
Yes.
No assault was given by accused Hemananda, but the witness voluntarily states that he was assisting his father.
accused Hemananda was not armed with any weapon. Very
Your
clear.
lordship, your lordship, right.
It's
So,
so
first instant, your lordship.
So this shows the conduct
The
of the
hon-
witness,
yes,
the demeanor of the witness. Had the demeanor of the witness to improve the case, he would have stated this, that yes, he also had the weapon in his hand. Nothing. He is very clear on this.
so. What is your comment on this particular witness further? PW3.
my submission before your lordship now that the appellant, the Hemananda Dehuri, only the restraint the deceased, namely Savitri, and the second part of that cross-examination
Is not to be believed.
not be believed.
Okay. You mean to say that even if he has restrained the movement of one of the deceased, it would not attract offense under section 302 IPC with aid of 34. That is your submission. All right. Next, come to the next witness, PW4.
Page 77.
Yes.
The next.
She is the daughter of that Savitri, right?
Yes.
Yes. And Giridhari also.
Minor child. Class standard 10 law.
Yes.
That the informant Manikya Puruste is the younger sister of my mother. Deceased Firavati Behera is my maternal grandmother. Deceased Savitri Sahu is my mother. Deceased Giridhari Sahu is my father. I know the accused person who were standing in the dock. The alleged incident was happened on 21st 10 2020. On the previous day, my Mausi, the informant, along with her 2 children and my Mausa had came to our house on the eve of Dasara. On 21st 10 2020 morning, at about 10 a.m., my Mausa went away. At morning, my mother, father and maternal grandmother had gone to our cultivable land. At about 12:30 p.m., they came to the house after taking lunch. At about 2:30 p.m., again my father went to our land. After a while of the departure of my father, my mother and maternal grandmother went at a little distance. This is the occurrence. Little distance from our house, there is a well. While my maternal grandmother was pumping the well and my mother was pouring water in bottle, accused Nabin Dehuri came and dealt a blow on the head of my maternal grandmother by means of budia. My maternal grandmother fell down on the ground. Thereafter, he dealt 3 blows on her neck. While my mother went to the rescue, my maternal grandmother, accused Hemananda and alias Mantu, restrained my mother by dragging her hair and accused Nabin assaulted by means of budia. Following my mother and grandmother, myself, my mausi and my brother had came outside and had seen the incident standing near our door. While I was trying to proceed to my mother, Mausi restrained me and she took me and my brother inside the house and closed the door. We raised hula. Hearing our hula, some villagers came to the spot. After arrival of the villagers, we came outside. I took the mobile of one of the villagers and informed the incident to my Musa, Uday Chandra Puste. The villagers did not allow me to go near my mother and maternal grandmother. Both of the were lying dead there. Accused Nabin Dehuri was shouting and telling that he has killed Kirmiria. Later on, we came to know that he has killed my father in our cultivable land. relating to this incident, I was examined by police.
So the role that is attributed by this PW4
Yes, ma'am.
is almost same
Covered
like PW3.
PW3.
And what you have brought in the cross-examination?
Cross-examination, you lost straightway the last page 80.
No, again, this contradiction you see, paragraph 4, एगुड़ाक प्रमाण ହେଇଛି ଆପଣଙ୍କର PW20 page ହଉଛି 136 paragraph 31. You come to that because all these things were pointed out to us. We also verified on that day.
Yes.
You see, come to page number 136.
130 page 31.
Paragraph 31.
Para 31.
Read it out.
It is a fact that the witness, namely Swapna Sahu PW4, has not specifically stated that before me that the accused dealt 3 blows on the leg.
Contradiction टा होची actually ଆମେ ଦେଖୁଥିଲୁ 161 से न ଏ जो तीनिटा blow मारला सेटाକୁ specifically तीनिटा blow कहनी but अन्य जिंस सब होची. We'll go to that 161 ने continue करंतु.
Blows on the neck and maternal grandmother, and that while she was trying to go to her mother, her aunt restrained her and took herself and her brother inside the house and closed the door, and that at the time of incident her maternal grandmother was pumping the tubewell and her mother was pouring water in the bottle, and that he informed the incident to her uncle Musa over phone, and that the door was half open, and that while her mother and maternal grandmother went to the door, her aunt went to close the door, and she along with her brother followed her, and that she linked along with the brother standing by the side of her aunt near the door and saw the incident through the half open door, and that accused Montu dragged the hair of her mother.
अच्छा ये जो जिनसटा हेयर टाकू स्पेसिफिकली कहिनी जो अटकेला बेली धरिकिनी. Now you come to the 161 of this girl ତା ନାଁ ହଉଛି ସ୍ୱପ୍ନା ସାହୁ.
Yes, ma'am.
ସ୍ୱପ୍ନା ସାହୁର 161 ବାହାର କରନ୍ତୁ.
Yes, ma'am.
ସେଇଠିକି ପଳେଇ ଆସନ୍ତୁ ଯୋଉଠିକି ସେ ମାଡ କଥା ଆରମ୍ଭ ହେଇଛି. ଆଗରୁ ପଢିବା କିଛି ଦରକାର ନାହିଁ.
ଆଜ୍ଞା.
ହଁ. सेकेंड पेज को पळेଇ ଆସନ୍ତୁ.
Second, ଆଜ୍ଞା.
ହଁ.
ସେଠି ମଣ୍ଟୁ ଦେହୁରୀ.
ନାଇଁ ନାଇଁ ସେକେଣ୍ଡ ପେଜ ରେ ଆରମ୍ଭ ହେଇଛି ଆଇ ଯିବାର କିଛି
ସମୟ ପରେ ମୋର ଆଣ୍ଟି କବାଟ ଦେବାକୁ ଉଠି ଗଲେ, ପରେ ପଛେ ପଛେ ମୁଁ ଓ ମୋର ଦାଦା ବି ଗଲୁ. ମୋର ଆଣ୍ଟି କବାଟରୁ ଅଧା ଖୋଲା କରି ରହିବାରୁ ସେ ଫାଙ୍କା ଆଡୁ ମୋର ମାଉସୀ ପଛରେ ରହି ମୁଁ ଓ ମୋର ଦାଦା ଦେଖିଲୁ ଯେ ମୋର ଆଈ ବୀରବତୀ ବେହେରା ଯାତ୍ରା ମଣ୍ଡପ ନଳକୂପ ପାଖେ ପାଣି ମାରୁଥିବା ଜାଗାରେ ଥିଲା ଓ ଆମ ଗ୍ରାମର ଆମ ପଡୋଶୀ ନବୀନ ଦେହୁରୀ ତାକୁ ଟାଙ୍ଗିଆରେ ହାଣୁଥିଲା. ସେଠି ମଣ୍ଟୁ ଦେହୁରୀ ପାଖେ ଠିଆ ହୋଇଥିଲା. ପରେ ମୋର ମା ନଳ କୂଅ ପାଖକୁ ଦୌଡୁଥିଲା. ନବୀନ ଦେହୁରୀ ମୋର ମା ପଛେ ପଛେ ଗୋଡାଇ ଗାଁ ଦାଣ୍ଡରେ ତାକୁ ଟାଙ୍ଗିଆରେ ଚୋଟ ଉପରେ ଚୋଟ ମାରିଥିଲା. ମୋର ମା ତଳେ ପଡିଯିବାରୁ ମୋର ମା ଦୌଡୁଥିବା ବେଳେ ମଣ୍ଟୁ ଦେହୁରୀ ମୋର ମାକେ ଛେକ୍ ଦେଲା, ହେଲେ ମୋର ମା ଭାଗ ପାରିଲା ନାହିଁ. ଏସବୁ ଦେଖି ମୋର ଆଣ୍ଟି ଡରେ କବାଟ ଛାପିଦେଲା. ନବୀନ ଦେହୁରୀ ମୋର ମାକେ ହାଣି ସାରି ଟାଙ୍ଗିଆ ଧରି ଆମ ଘର ରାସ୍ତା ଦେଇ ତାର ଘରକୁ ଗଲା ବେଳେ କହିଗଲା ଯେ କବାଟକେ କିର୍ମିରାକୁ ହାଣି ଦେଇଛି, ହେଲେ ଆମେ ସବୁ ଘରେ ପଶି ପାଟି କରୁ.
ତାହେଲେ ରିଷ୍ଟ୍ରେଣ୍ଟ ଯୋଉ ୱାର୍ଡିଂ ଟା 161 ଅଛି ନା ନାହିଁ ଯେତେବେଳେ ସେ ଯୋଉ ସାବିତ୍ରୀକୁ ଦ୍ୟାଟ ଇଜ ଦେୟାର ଛେକି ଦେଲା ମାନେ ହିଁ ହଉଛି ସେଇଆ ହେଲା. ତ ଏଠି ଏକ୍ସଟ୍ରା ଟା କଣ ହେଇଛି ନା ସେଇ ଯୋଉ ଢାଳ ଧରିକି ରାଇଟ. ତେଣୁ ଯୋଉ କଣ୍ଟ୍ରାଡିକ୍ସନ ପଚରା ହେଇଛି
that is in a broader sense taking all. So there is substantially there is no omission, but there is manner of description.
हाँ,
Chekka.
he produced he produced a dictionary. I think the other day Mr. Kotkia produced a dictionary जोटा कि लेखा है जी छेकी देला माने होची अटकाइला हला restraint. We have kept it. So anything else you want to point out from
And
this?
your lordship's kind of page 70, the cross-examination PW 4 lord. That
and you come to the last line, paragraph 11, page 80.
Yes, my lord. Page 80, para 80. Yes, my lord. Accused Hemananda was not armed with my weapon. It is the fact that that no assault was given by accused Hemananda. He had only restrained my mother.
So very fairly he has stated
Yes,
that no, this is the role. So the role, your role is consistent. That is the evidence of ये एक नंबर टिके एपट सेपट करूची बट तीनी चारी एवं ये रु आसुची जे you are not holding any weapon and you have not actually assaulted with this one, so but your role is this. Okay, you are
not drying her hair also. ଚୁଟିଟା ଯୋଉ ଧରିବା କଥାରେ ବି କୋଉ ଟିକେ ମାନେ କେହି କହିନାହାନ୍ତି.
No, such a ghastly incident has happened in the family.
No, your lordship.
And it cannot be expected that the witnesses will be so tranquil to give such a statement.
ସେଇ ଦିନ ସେମାନଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ରେକର୍ଡ ହେଇଛି, ସେମାନେ ୟୁଜ କରୁଛନ୍ତି ଛେକି ଦେଲା ହେଲା, ତାପରେ କମ୍ପୋଜର ଆସିଲା, what has been pointed out, ସେ କହୁଛନ୍ତି ଏଇ ପ୍ରୋସେସରେ ତାକୁ ଅଟକେଇଲା, ମାନେ ଚୁଟି ଧରିକି ଅଟକେଇଲା. ତେଣୁ so now what is your submission regarding 34 which is addressed to ଆମେ ଆପଣଙ୍କୁ କହିଦେଇଥିଲୁ ସେ ତାଙ୍କର କାରଣ ଆର୍ଗୁମେଣ୍ଟ ଥିଲା ମିଷ୍ଟର କଟକିଆଙ୍କର ଯେ ଆପଣ ଯଦିଓ ଫାଷ୍ଟ ସିନ୍ ଅଫ ଅକରେନ୍ସ ରେ ନଥିଲେ, ସ୍ପଟ ରେ ନଥିଲେ ଯୋଉଠି ଗିରିଧାରୀର assault ହେଲା, but when your father was returning holding a bloodstained tangia, on the way you joined your father because at the second spot both of you came together, right? Number one. Number two, you were present till all the assault was over. The two deceased, mother and daughter, entire assault was over, you were present, right? He stated that your presence at the spot rather gave courage to the first accused to commit the murder of the two deceased, because there was every risk that the villagers may come and create any disturbance or prevent the Naveen from assaulting.
Yes, sir.
Because of your presence, he got the courage and could succeed in assaulting the two deceased and giving them number of blows. And in addition to that, when one deceased was going to rescue the other one, you also restrained the movement. And the restraint of the movement is that by holding the tuft of the hair.
Yes, sir.
So that what the effect was that he could succeed in assaulting the deceased persons, giving more blows to the first that mother and also assaulting the daughter Savitri. So then both of you left the spot together.
Yes, sir.
And he has not restrained his father.
You have not checked your father that not to commit the crime. So omission and commission is dita jinsa madhya, that is he cited one or two decisions on that point. That 34 को हमें जज केमती करिवो हैला, 34 नुहे जे समस्ते तांको assault करिवे. Actual assault 34 उद्देश्य नुहे जे समस्ते assault कले ही 34 हबो, नहले हबो नाही. So common intention रे किए को प्रकार शेयर करछि तांकर रोल मध्य डिफरेंट हेई पारे, but if the intention is common, in furtherance of the common intention, the role played by each of the accused may vary.
Yes, ma'am.
And that is to be judged what is your conduct prior to the actual assault, at the time of assault, and after the assault. From that, the court can judge it. Right? So, ethi apanakara yeru see submission guda kouchanti backed by some citation.
In this case, Lord, that vice submission in section 34, not at all attacked also.
Advance your argument. We are that is exactly
No, that's the
we
law.
are making it very clear. Let us say evidence has come, you are not holding weapon.
Yes, ma'am.
You have not actually assaulted any of the sworn. So your role is this, but in spite of this, his submission is 34 is attracted, and your submission, no, it is not attracted.
Yes,
it will
ma'am.
not be attracted.
Yes, ma'am.
Advance your argument, cite the decision.
Yes, ma'am. That the
Keeping in view the submission of the prosecution side,
Yes.
as Mr. Kaskia has raised,
yes,
what active and passive.
yes,
Once you do not contradict the position with respect to the presence of the present appellant
yes,
in the scene of occurrence. Once the presence of the appellant is there in the scene of occurrence, then the question of active and passive both comes.
Yes.
That is what was argued.
Well, the 34, section 34, in this regard, when in our High Court, that one judgment 2021.
Cite, there is no problem. Proceed. 30. We are. That is why we are hearing you.
Proceed.
To
2021, volume 82 OCR, page 251. There is the allegation of trial conducted 302 and 34, my lord.
No, what is the name of the party?
Party, my lord, the Kaleshwar Majhi and
Kaleshwar.
Kaleshwar
Majhi, acha.
and others versus State of Odisha. Paragraph 16.
Paragraph 16 is important. All right, please.
Paragraph 13 and 16.
13 and 16.
Yes.
Okay.
13, my lord. In our considered opinion, the conduct or other evidence available in this score must be such so as not to leave any room for doubt regarding the developed common intention. Before coming to a conclusion and holding that the appellants have a vicarious liability, the court must satisfy itself as to the prior meeting of minds of the principal culprits and his companions, who are sought to be constructively made liable in respect of every act committed by the former, whether there was common intention or not, to depend upon fact and circumstance of each case. The intention of the principal offender and his companions to deal with any person must be apparent from the conduct of the person accompanying with any person, must be apparent from the conduct of the person accompanying the principal culprit. There must be some other clear and cogent incriminating piece of evidence. When such materials are absent, the companions cannot be justifiably held guilty of every offense committed by the principal offender. The evidence regarding development of common intention to commit an offense graver than one originally designed during execution of the original plan should be clear and cogent. In this case, we have seen that there is no clear and cogent material record to show that the appellant who brought to the deceased from his house and tried him to tree and then assault by means of lathi did not have the intention to commit his murder.
That's a different factual scenario is different. I'm giving one an example.
Yes, ma'am.
Suppose X is an accused,
yes,
Y is another accused.
Yes, ma'am.
So X called the Y, let us go to A. And both of them went together. And when they reached near A, there was some kind of altercation. And during that altercation, A suddenly brought out a knife, which he was having, stabbed the A. So this man who was accompanied,
yes,
he was not aware that X was having any weapon,
Yes.
right?
Yes.
So he was present at the spot,
Yes.
let us say. They came together, and it may be that they left together. But mere presence at the scene of occurrence, you can find number of reasons. Mere presence at the scene of occurrence will not automatically attract section 34.
Yes.
Because many person may go together, many may join at the scene of the occurrence. Even 149, same principle has been laid
Yes,
down.
my lordship.
Okay. So let us say somebody was going, somebody just joined that A, and somebody was mere spectator to see what was going on. So that doesn't mean that whosoever was present at the spot, they will be with 149, they will be found.
Yes.
But here is a case, it's a different thing. What he is pointing out, father, after committing the murder, was coming to the second spot holding a tangia with bloodstain. So obviously, you cannot say I was not aware that my father was having a weapon. He was holding the tangia.
The first occurrence,
You are not there. There is no evidence you are there. But when you came to the spot with your father,
Yes.
to the second spot, that means you joined somewhere in between that 700 meters, somewhere you joined. So that is how your presence has been seen by all these persons. କାରଣ ଆପଣ ଜଣେ ପାଣି ମାରୁଥିଲା ଆର ଜଣକ ବଟଲରେ ପାଣି କଲେକ୍ଟ କରୁଥିଲା ବେଳେ ଆପଣ ଦି ଜଣ ଯାକ ଆସି ପହଞ୍ଚିଲେ ବାପା ଆପଣଙ୍କର ଧରିଥିଲା ଟାଙ୍ଗିଆ ତେଣୁ ବାପା ଫାଷ୍ଟ ସ୍ପଟ ରୁ ସେକେଣ୍ଡ ସ୍ପଟ ର ଦୂରତାଟା ହଉଛି 800 ମାନେ 750 ମିଟର ଯାହା ବି ହଉ ତେଣୁ ଆରି ଭିତରେ ହିଁ ଆପଣ ଜଏନ କରିଛନ୍ତି ଆପଣ ଜଏନ କରିଛନ୍ତି କେମିତି ନା ଆପଣଙ୍କ ବାପା ଟାଙ୍ଗିଆ ନେଇ ଆସୁଥିଲା ରକ୍ତ ଲାଗିଥିଲା ତାକୁ ଦେଖିକିନି ମଧ୍ୟ ଆପଣଙ୍କ ବାପାଙ୍କ ସାଙ୍ଗରେ ଜଏନ କଲେ that means you are very much aware that what my father was carrying.
No, nobody can stated that my father ବାପା ଟାଙ୍ଗିଆ ଧରିକି ଆସିଲା ମୁଁ ଜଏନ କଲି ଏଇ ଜିନିଷ କୋଉଠି ଆସିନି
ଆରେ it is court can presume certain thing. There are certain things which the court can presume that you have joined somewhere in between. First spot re you are not there.
Yes.
Second spot re where you are there. So in between you have joined your father, and your father was having the weapon with him, bloodstain axe.
And also having blood patches on his
blood patches on the of course on the is right on the clothes also. ତେଣୁ ସେଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ବାପାଙ୍କ ସହିତ ଆପଣ ଜଏନ କରି ସ୍ପଟ କୁ ଆସୁଛନ୍ତି ଏବଂ ସ୍ପଟ ରେ ଆପଣଙ୍କର ଓଭରଟାକ୍ଟ ହଉଛି ଏଇଆ ଯାହା ଏଭିଡେନ୍ସ ଆସିଛି ବାପାଙ୍କୁ ଆପଣ ରିଷ୍ଟ୍ରେନ୍ କରୁନାହାନ୍ତି ଯେ ନାଇଁ ବାପା ଏଗୁଡାକ କରନି ଆପଣ ରାଦର ଯିଏ ଗୋଟେ ଡିସିଜ୍ କୁ ବଞ୍ଚେଇବାକୁ ଯାଉଛି ସେ ଲେଡିକୁ ଆପଣ ଅଟକଉଛନ୍ତି ପ୍ରିଭେଣ୍ଟ କରୁଛନ୍ତି ଏବଂ ବାପାଙ୍କ ସାଙ୍ଗରେ ଏକାଠି ସେ ଜାଗାକୁ ଛାଡି ଯାଉଛନ୍ତି ତ ଏଇ ଯୋଉ ଫ୍ୟାକ୍ଚୁଆଲ ସିନେରିଓରେ can it be said that you are just present at the spot, mere presence?
So besides the fact that the prior meeting of mind is also one of the factors that is to be taken in section 34, which is having a very thin line to distinguish from 149 of developing a common object at the very spot. This is also one of the ingredients that is need to be seen at this stage from the overtake, whether he had meeting of mind or not. So the act overtake precedes the intention of the person, common intention. So there are various aspects where the appreciation has to be made. It cannot be a straight jacket kind of thing. Maybe because of this, one of the reason Mr. Sarangi, you may endorse that his argument was more with respect to the fact he ruled out the possibility of the witnesses having seen the occurrence. Instead of going for the nitty-gritty of the evidence, he argued more on ruling out the possibility of the witness having seen the occurrence.
Prior meeting of mind, you see, it is not that at some places they sat together, decide to do it. A type of evidence asini ba asi pariboni sabu case re. Hela? Kintu prior meeting of mind, se କହିଲେ ताको केमती जज करिवो जदि प्रायर ऑफ मीटिंग ऑफ माइंड रो किसी डायरेक्ट एविडेंस नाही ताले how it is to be judged that yes they had some kind of meeting of mind for which this thing happened, and this can be judged from what has happened at the scene of occurrence. So, anything further you want to advance argument for Rudanand Tehuri?
No, my lord, that another one judgment. my lord.
Hemanand, sorry.
Yes,
Hemanand.
another one judgment, my lord. that
Yes.
is court, my lord. Lastly, in 2017,
Hmm.
Criminal Law Journal,
Hmm.
page 4228.
Hmm.
4228.
Hmm.
State of Orissa versus Matamunda and others. ଏଠି ବି ଡେଥ୍ ରେଫରେନ୍ସ ସହିତ ଜେଲ୍ କ୍ରିମିନାଲ ଅପିଲ ଶୁଣାଣି ହେଇଥିଲା। ସେଥିରେ ଅଲ୍ଟରେସନ ଅଫ ସେଣ୍ଟେନ୍ସ କଲେ ଫର ଦ ଡେଥ୍ ଆଣ୍ଡ ଲାଇଫ ଟାକୁ ଆକ୍ୟୁଟାଲ କଲେ ଇନ ଦିସ୍ ସିନାରିଓ। ଅଲ୍ଟରେସନ ଅଫ ସେଣ୍ଟେନ୍ସ କଲେ
No, your client
And the life was set aside.
Light was
No, there are cases where death reference has also been completely set aside. Complete acquittal.
No, no, my case, my lord.
One of the cases, my lords, one child sacrifice of Balimela. This court, death sentence, the judgment was death sentence for 6 persons. They were acquitted before the
No, other cases are also there where series of murder is there in the same transaction and death reference has been set aside completely. The entire.
That matter was 4 accused persons were there. 2 have been convicted and 2 have been acquitted. Matamunda case, I was arguing that matter.
Each case has to be taken in its
So, this case which you cited,
yes,
2007, for what purpose? जोड़ा प्लेस कर ले कौन माने लाइव जाऊ दिया ला सेट असाइड कला माने कौन माने फैक्चुअल सिनेरियो ना
the evidence that the prosecution proved the charge against the accused was beyond all reasonable doubt.
That's all. Yes.
The paragraph 15. Paragraph 15, 16, and lastly 24. Lastly 24.
Have you find out any decision?
Yes, ma'am.
Where one accused, one deceased was assaulted.
Yes.
Somebody was going to rescue. Here is the deceased. Somebody was going to rescue that deceased, and he was prevented by one accused to interfere with the assault. And the court has held that no, 34 would not be attracted. His role is, they have saying that those who wait and serve, the proposition is like this. Those who wait, they also serve.
Yes.
That is not applicable in every case. There has to be that kind of evidence. Hala?
Yes.
Tenu ଜଣକୁ assault ହଉଛି, ଗୋଟେ ସାକ୍ଷୀ ଯାଉଛି ତାକୁ ରେସ୍କ୍ୟୁ କରିବା ପାଇଁ, ଆଉ ଗୋଟେ accused ତା ମୁଭମେଣ୍ଟ ଟାକୁ ଅଟକେଇ ଦଉଛି, ଅର୍ଥାତ ସେ ସାକ୍ଷୀକୁ ପ୍ରିଭେଣ୍ଟ କରୁଛି ତାକୁ ବଞ୍ଚେଇବା ପାଇଁ। ସେଠି 34 ରେ କନଭିକ୍ସନ ହେଇଛି ଏବଂ ରେସିଓ ହଉଛି ଯେ ତାର ରିଜନିଂ ହଉଛି ଯେ ହୁଏତ ଇଏ ଯଦି ଇଣ୍ଟରଫିୟର କରିଥାନ୍ତା ସେ assault ହେଇ ନଥାନ୍ତା ହେଲା ଏଇ ଜିନିଷରେ, ତେଣୁ ତାକୁ 34 ଲାଗିବା ଦରକାର। ତେଣୁ ତାକୁ court interpret କରିଛନ୍ତି that it is not that in every case wherever a person, those who wait, he also serve, that principle is not applicable in every case. It is to be, it differs from case to case.
Yes,
ହେଲା ତ କିଏ ଗୋଟେ ରେସ୍କ୍ୟୁ କରିବାକୁ ଯାଉଛି ତାକୁ assault କୁ ଅଟକେଇ ଦେଲେ କମନ ଇଣ୍ଟେନସନ ହବ କି ସବୁ କେସରେ ତେଣୁ they have gone to the extent ତେଣୁ ଆଉ ଗୋଟେ କଟହୋଲ୍ଡ ଅଫ ରେ ଅଛି ଯେ ଜଣକୁ କଟହୋଲ୍ଡ ଅଫ କରିଦିଆଗଲା ଆଉ ତାକୁ assault ମଧ୍ୟ ହେଲା ତେଣୁ ସେମାନେ କହୁଛନ୍ତି ଯେ the decisions are like this that it is not that there is any evidence that he continued to restrain the movement of the deceased till all the assaults were over. ସେ ତାକୁ ଅଟକେଇ ଦେଲା ଇଏ ତାକୁ ଆଟାକ୍ କଲା ତାପରେ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଯୋଉ ଅନ୍ୟ assault ଗୁଡାକ ତା ଉପରେ ହେଇଛି deceased ଉପରେ while he was restraining the movement all the assaults took place. So ଅଟକେଇ ଦେଇଥିବା ଠିକ ଅଛି but unless you show that your restraint facilitated the other accused to cause all the injuries. So whether in that case 34 would be attracted or not. বিভিন্ন প্রকার thin line of ইয়ে analogy distinction କରିଛନ୍ତି 34 କୁ deal କରିକି ଚାଲିଛନ୍ତି. So those who wait they also serve that proposition is not applicable. That line also you click Manu Patra, you will find distance. One that one who waits also serves not applicable for 34 in every case. You can get the distance. ଆଉ ଗୋଟେ decision ଯୋଉ କହୁଛି ଆପଣଙ୍କୁ continue to catch hold of the deceased till all the assault was over. There is no evidence whether 34 would be attracted or not. So ଆପଣଙ୍କର ନା evidence ବହୁତ squeeze ମାନେ limited ଜିନିଷ ସେତିକୁ ଆପଣଙ୍କୁ focus କରିବାର ଅଛି ସିଏ ଯୋଉ ଜିନିଷ advance କରୁଛନ୍ତି how do you meet it, right? So if you have got all those decisions please cite us, otherwise we'll herein close the argument and you can supplement it by citing some filing written note of argument or by citing some decisions.
My senior criminal appeal almost all arguments over.
No, we told you, na, he has covered both the appellants. It's not that he is only arguing on behalf of that death sentence or that Naveen. He argued also for this Hemananda Devuri. In presence of both the clients, we told him that Mr.
That is how we told that his argument was twofold. One on the merit of the case, the other one ruling out the possibility of the witnesses having seen the occurrence. So ruling out the possibility of witnesses having seen the occurrence gives a goodbye to everything. That is how very intelligently he argued on that part first. And secondly, he came to the intricacies of the evidence. All right.
Anything further you want to say?
Your Lordship, the finding of the trial court. Your Lordship, kindly turn to page 173.
On your accused?
Yes, ma'am.
On 34? Aji discussed about your role?
Yes, ma'am. That 173.
173. Okay, let us go to that.
Paragraph?
The paragraph 17.
17?
Yes, ma'am.
17?
Yes, ma'am.
Yes.
In the affair, the informant has stated that the accused persons assaulted her mother and sister near the well of the village by means of an axe. The accused persons proclaimed at the spot that they have already killed Kiridhari, but she has later mentioned in the affair, not stated in the IO, in her statement regarding the number of blows given by the accused Naveen to her mother and sister. as she for the first time stated in her evidence in chief. One material contradiction has been rightly pointed out, that she has not mentioned on the FIR or in the statement before the IO that the accused Hemananda has restrained her sister Savitri by holding her chair.
Yes, we do agree.
It is not there.
We do agree.
FIR ରେ ନାହିଁ ଏବଂ ଇଏରେ ଅଛି 161 ଅଛି ଛେକି ଦେଲା
ଆଜ୍ଞା
ଏମିତି ହୋଲ୍ଡିଂ କରି ଛେକି ଦେଲା ବେଳେ ନାହିଁ.
ଯେ ନାହିଁ.
Right, yes. Which is that paragraph in which Hemananda role for that 34 has been discussed and the court has come to the conclusion that he is to be convicted with head of 34. Which is that paragraph?
My lord, your lordship can turn to page 203. 203, para 57. For sake of argument, let's accept that the accused Hemananda, for the first time, spot where the deceased Savitri and Puravati were murdered. At the other from repeating such brutal act again, but his subsequent conduct seriously exposed him. Puravati died at the spot, and while deceased Savitri proceeded for rescue of the Puravati, the present accused prevented her, knowing it well that his father has already committed murder, or giving the fatal blow of Puravati. This is sufficient to establish the guilty mind of the present accused to assist his father, Navin, for commission of the crime. That apart, after commission of murder, both the accused person declared that they have already committed murder of the Giridhari, which conveys the court that prior commission of murder of Piravati and Savitri, it was within the knowledge of the Hemananda, and that his father has already killed Giridhari. It is a clear case of the against the accused Hemananda that he was not only the sharing the common intention with the accused Navin, but also the active participant in the crime.
So these are the reasons which have been given by the London trial court,
Yes,
right?
yes.
So so how do you meet it? How do you meet it? This this reasoning which has been assigned by the London trial court for convicting the Hemananda for 302 with head of 34 is not a good reason, is not a sound reason, and which is that decision you were placing, Mr. Katkia, the other day, that somebody has not prevented one to the passive act. You cited one decision. One decision, I think, that he did not restrain his father to commit the crime.
Yes, omission. That is an
omission.
Yes.
He rather his presence of the moral boost, we can say that.
It is Ajay Kumar Das.
See, what a decision upon say line
Yes,
taku. We have taken note of it, of course. Now, Ajay Kumar Das versus State of Jharkhand, 2011-12 SCC 319,
Yes.
paragraph 10 and 11.
Yes.
Please place that once again.
Our attention is also drawn to Mehboob Shah versus King Emperor. In the said decision, it was held that to invoke the aid of Section 34 IPC exclusively, it must be shown that the criminal act complained against was done by one of the accused persons in furtherance of the common intention of all. And if that is shown, then the liability for the crime may be imposed on any one of the persons in the same manner as if the acts were done by him alone. It was further held that it is difficult, if not impossible, to procure direct evidence to prove the intention of an individual. In most cases, it has to be inferred from his act or conduct or other relevant circumstances of the case. This court in Bengai Mandal versus State of Bihar, after referring to some allied decisions of this court, held that the position with regard to Section 34 IPC is crystal clear and that the existence of common intention is a question of fact. It was held that since intention is a state of mind, it is therefore very difficult, if not impossible, to get or procure direct proof of intention, and therefore courts in most cases have to infer the intention from the act or conduct of the party or other relevant circumstances of the case. Unless another decision.
Cited one Ramesh Singh versus State of AP,
That is the relevant.
paragraph 12, 16, and 17.
That's the judgment what you lost, sir. Yes. It is 12, para 12.
12, 16, 17 upon place करतले sir.
Yes, 12 from last 4 lines, page 314. That is the contributory acts of the person who are not responsible for the injury can further be inferred from the subsequent conduct after the attack. In this regard, even an illegal omission on the part of such accused can indicate the sharing of common intention. This is an omission.
Come to paragraph 16, 17 you placed on that day.
Yes. A2 is the person in this case what the grievance that the disease prevented him from collecting the bhajan samagri, prayer material, for the use at the funeral of his relative. In the case of prosecution, that all the accused persons came together to the place of incident at 11 o'clock to demand the bhajan samagri. The fact that A1 and A3 were not concerned with the need of A2 to collect the bhajan samagri still came together at that time of the night, that is at 11 p.m. so that A1 and A3 were associates of A2. After failing to get the samagri, all the three went together, presumably to the house of A2 at 11:45 p.m. Again, these three persons came to the house of the accused, which act cannot be termed as a normal act because by that time most of the people, including the deceased, would have been or had been sleeping. When these accused persons summoned the deceased to come out of the house, obviously they had some common intention, which is their second visit. Timing of the visit and calling of the deceased indicates. Once the prosecution evidence tendered through PWs 1 to 3 is accepted, then it is clear that when A2 and A3 held the hands of the deceased, they had some intention in disabling the deceased. This inference is possible to be drawn because the appellants in their statement recorded under section 313 CRPC didn't give any explanation why they held the hands of the deceased, which indicates that the appellants had the knowledge that A1 was to assault the deceased. The fact that the appellants continued to hold the deceased all along without making an effort to prevent A1 from further attacking, in our opinion, leads to an irresistible and an inescapable conclusion that these accused persons also shared the common intention with A1. In these circumstances, what was the intention of A1 is clear from the nature of weapon used and the situs of the attack, which were all in the area of chest, penetrating deep inside and which caused the death of the deceased. It is very difficult to accept the defense version that the fight either took place suddenly or these appellants didn't know that A1 was carrying a knife or that these appellants didn't know by the nature of injuries inflicted by A1 that he did intend to kill the deceased. At this stage, it may be useful to note that A1 didn't have any motive apart from common intention to attack the deceased. In such circumstances, if A1 had decided to cause the injury and A2, who had a direct motive, had decided to hold the hands of the deceased with A3, in our opinion, clearly indicates that there was a prior concern as to the attack on the deceased. We also notice that thereafter the accused persons had all left the place of incident together, which also indicates the existence of a common intention. Having thus independently considered the facts and circumstances in their totality and taking a holistic view of the facts of the case, we are of the opinion that the two courts below are justified in coming to the conclusion that the appellants are guilty of an offence punishable under section 302, read with section 34 vibes.
Yes. Anything else, Mr. Lawes?
And on the last occasion, Lord, the written notes of submission filed by the state, Lord, also stated that the same point of view, page 10, this man admin question, my role is under section 34. On the basis of PW 1, 3, and 4 statement.
ଯେତେବେଳେ ମା ପ୍ରଥମେ ଆସଲ୍ଟ ହେଲା ଝିଅ ଯାଉଛି ତାକୁ ଅଟକେଇବା ପାଇଁ ମାନେ ପ୍ରିଭେଣ୍ଟ କରିବା ପାଇଁ ସୋ କେତେ ଗୁଡେ ଜିନିଷ ବି ହେଇପାରିଥାନ୍ତା ହୁଏତ ସିଏ accused କୁ restrain କରିଦେଇ ପାରିଥାନ୍ତା ତାଠୁ might have succeeded in snatching away the axe, might have fallen on her mother to save her mother from further assault. So many things would have happened. So this restraint movement might have done the PW that appellant to complete all the assaults on the mother and so also this lady Savitri. ତେଣୁ ମୁଭମେଣ୍ଟ ର ଯୋଉ ମୋମେଣ୍ଟ ରେ ମୁଭମେଣ୍ଟ ଟାକୁ ରିଷ୍ଟ୍ରେନ୍ କରାଯାଇଥିଲା ଯଦି ମୁଭମେଣ୍ଟ ରିଷ୍ଟ୍ରେନ୍ କରା ନ ହେଇଥାନ୍ତା ଏଇ ଜିନିଷର ହବାର ପସିବିଲିଟି ଥାନ୍ତା ବିକଜ ଅଫ that restraint these things could not took place. That is also another factor to be seen. So many things ये जो delicate जिनिष गुड़ाक ना 34 को जो judge करा जाउची को position ने join करले कौन करले अपन करो throughout your presence what you have done and apart from that what you could have done ये जो omission कथा डाउचंदी कमिशन खाली हबनी ओमिशन मध्य सेटाकू जोटा करले तेणु whether it is a case of mere presence we have no idea that what will take place there so mere presence having no idea what the other accused is likely to do is some completely different. Then you know your father had done something, coming prepared to assault, joining him, remaining present there throughout till both the assaults were over, and also some extent participating in restraining the movement. Whether in all this factual scenario 34 would be attracted or not. So if you have nothing further to argue, then we can close the argument.
Yes, I have cited two types of judgment, but under section 34.
Today. No, we'll we can close because this court is not there for tomorrow. It is not there.
No, Monday. I only think that the section 34 not applicable in my case.
No. Since you are not there from the beginning of the argument, we opened off everything. What Mr. Sadangi said, what Mr. Katkia presented. Now also you are well versed that what is their argument. Now we are also putting you opening of that these are the hurdles in your path to meet 34. So you can take some time on Monday. We can close the argument. There is no, because one has been sentenced to death, other is life. If you want 2 to 3 days for further preparation, there is absolutely nothing.
That my submission.
But if you have already prepared and finished your argument, there is no further thing to be keep again on Monday. So we are.
I will supply the two judgments not under section 34.
No. Whether you want, then let it come on Monday and only for this supply of this written note of citation or judgment, whatever you may say. If you are not having those judgments, or you may during this period of 2 to 3 days, something may strike to your mind, and you may find many on some decision. You can cite. There is no problem. No. Sorry, we are not creating any hurdle on your path. We are giving you full opportunity.
Yes,
because one is sentenced to death, other person is life, and so it was exhaustively argued by the Learning Council for both the parties. You came, and we are also duty bound to give you opportunity. Okay, that is why we are having full-fledged discussion, so that you know that these are the things, these are against me, how I am to meet all these things. So what do you want? We'll keep it on Monday. You will cite for that written note of submission, and have you placed any written note of submission?
No, Milan.
So if you want to cite or file any written notes of submission or memo of citation of decision, whatever you may. And if you file the memo of citation, don't attach those Xerox copy of the judgment. Only give that paper that this is on this particular point, 34, this or relative witness, as you said, and this is the citation, reference, party name, and this is the particular paragraph.
Yes,
okay, only that much.
Yes,
not necessary to file
citations.
Not.
Yes, ma'am.
So, yes, Mr. Katkia intends to cite some decision. If you want to argue anything, can argue.
In addition to my oral submission, I have already given the written submission. But only whatever my learned friend has argued on interested witness related to this. Related to this cannot be said to be equivalent to interested. The word that has been said by the Honorable Appellate Court in 1981, Volume 2 SCC 752.
Just a minute. Yes, give the citation.
1981.
Yes.
Volume 2 SCC 752.
What is the name of the party?
State of Rajasthan versus Kalki and others.
Kalki.
Kalki, K-L-K-I. Paragraph 7 and 8.
7 and 8. Yes.
7 is important.
You can place it
Yes,
just a few lines.
As mentioned above, the one order of acquittal was under challenge for the Honorable Apex Court. As mentioned above, the High Court has declined to rely on the evidence of People 1 on 2 grounds. She was a highly interested witness because she is the wife of the deceased. And 2, there were discrepancies in her evidence. With respect, in our opinion, both the grounds are invalid. For in the circumstances of the case, she was the only and most natural witness. She was the only person present in the hut with the deceased at the time of occurrence, and the only person who saw the occurrence. True, she is the wife of the deceased, but she cannot be called an interested witness. She is related to the deceased. Related is not equivalent to interested. A witness may be called interested only when he or she derives some benefit from the result of a litigation. In the decree in a civil case or in seeing an accused person punished, a witness who is a natural one and is the only possible eyewitness in the circumstance of a case cannot be said to be interested. In the instant case, people 1 had no interest in protecting the real culprits and falsely implicating the respondents. And ultimately, the order of acquittal was reversed, and as because the accused persons were on bail, direction was passed to surrender all those accused persons to serve the remaining part of the sentence.
That's all for today. So we are keeping it on Monday and we'll close the that. Let me CR LA number 693 of 2024. Hemanand Deputy. Or Mr. Pranay Kumar Das, London Council, appearing for the appellant. So also Mr. Janmejay Katkia, London Additional Government Advocate, and Mr. Devasi Sarangi, who is the London amicus curiae in DS REF so and so, as well as JCRLA number so and so. Mr. Das cited some decisions and after finishing his argument, submitted that the matter may be taken off on 29th so that he will file written note of argument and memo of citations. Raise this matter on 29th of January, July 2024. All right. You bring it, just filing of memo of citations and written note of argument. Yeah. So, Mr. Katkia,
Yes,
that's all.
my argument is closed.
Mr. Das will come after lunch, of course, different bench is there.
I beg your pardon. One matter, item 56. That was a hearing item, Your Lordship. In that case, in 1998, the judgment was passed. Thereafter, a appeal was preferred in 1999. Thereafter, that was remanded back on 2010 for recording of the 313 statement, as well as a defense witness was examined, and it was again, appeal was preferred. In the meantime, 26 years elapsed, Your Lordship. So I pray the status of the accused can be called for release. Yes, madam. They were in custody probably from the beginning.
They were in custody.
Item 56. I was asserting from a London friend also, he also not aware of that thing.
I was examining the court documents. There also the evidence is also not there. Depositions are not there. Paperwork nahi मतलब मेरे में.
अच्छा.
Depositions. I'll collect the pen drive and yes.
Thereafter,
No.
accused statement was recorded in the court.
No, my lord. First judgment was on 13/11/9. 2009. Second, first judgment, the remand was on 13/11/9 from this honorable court.
So first judgment was in 75 of 1998.
1998, right.
So,
Right.
no, but that was passed in 2010.
No, 13/11/1999.
Initially,
2009.
was passed on 1990.
2009 it was remanded.
It is a case of 1998.
1998.
Disposed of by the trial court.
Six of the judge. Six.
May be pointed out here that originally my predecessor, so delivered the judgment on 28/99, completing the accused and into the sentence of rigorous imprisonment for life. Both the accused preferred appeal claims Swanso criminal appeal. The honorable court, in the federal appeal by the advocate Swanso, set aside the improved judgment and conviction, sentence along with the applicant, remitted back the case to this court with the direction to record the statement of the accused
This statement was not.
Yes, ma'am.
It creates at least, since no separate questions have been with accused persons about each material substances which is intended to be used against it. Accordingly, it having CRPC statements of the accused persons were recorded on 2010. Accused persons entered into the defense, examined one witness after rehearing the judgment.
Yes. So, my lord, in the meantime, 26 years has elapsed. The status of the accused kindly be, my lord.
The report shows that they have not been released on bail by
Not
But
released.
I have no knowledge.
No, not released. They are put in UTP. In the second judgment, they are put in. I was verifying the order sheet of the thereafter.
ଗୋଟେ ତ young ଥିଲା.
the other one was 40. ତାପରେ corona. So, we jail they are now. They are
Fulbani.
Fulbani. Direction kindly.
the Lieutenant Counsel for the state this side
56.
stated that since as for the improved judgment, the appellant Julie Doda waited about 60 years into judgment and certificate in 2010. The appellant Julie Doda was about 60 years and Fatima Doda was about 40 years. And in the meantime, more than 14 years passed and they have not been released on bail by the court. In this year, may be given some time for them to status of the case.
I passed it.
In this US
Not the correct.
It's a conviction real. Declares the accused to share premature delay. Or there is a whole life I can be told.
Material objective.